Hello and welcome to Daily Politics on Trust TV. On this program, we discuss issues around politics, policy and governance. I am Shafiu Suleiman, standing in for your regular host, Hamza Idris. Now, the Court of Appeal on Sunday, November 19, sacked the Governor of Plateau State, Caleb Mufwang, and declared Nantawe Goshwe of the All Progressives Congress, APC, as the rightful winner of the March 18 governorship election. The court ruled that Mufwang Party, the People's Democratic Party, PDP, violated a court order directing it to conduct a valid Congress in the 17 local government areas of the state. As a result, the court held that Mufwang was not validly sponsored by the PDP for the election. On tonight's program, we'll be talking to Barrister Emmanuel Mense Madaki. He's a senior lawyer. He will help us explore issues around this appellate court judgment. Thank you for joining us.
Thank you for having me.
Right. Okay, you followed this appeal, very diligently, right from the onset. The judgment of the Court of Appeal has generated a lot of reaction, and then it has various interpretations, so to speak. Let me get first your perspective. What do you make up with the judgment of the Court of Appeal?
Thank you very much for this wonderful moment granted to me to express first our position as a party or as one of the lawyers who participated actively in the proceedings leading to this judgment, and of course the dispassionate approach which we confronted these issues frontally in respect of the Plateau issues. Immediately after the general elections, of course, the petitioners, that is members of other parties who lost the election, approached the tribunal. And just like they sat in one place and drafted their petitions, because preponderantly their petitions were anchored on basically one ground. And the ground is that they did not come to the tribunal to say that they won elections. They did not come to the tribunal to say that the people of Plateau State voted for them, and that their votes were actually shortchanged or reduced by any means. But instead, they approached the tribunal to tell the Honorable Tribunal that indeed, we know that PDP won these elections overwhelmingly in Plateau State, but we want you to disqualify all the candidates of the PDP because PDP was in disobedience to court order.
Isn't that a valid request now, if you like? If that is the ground upon which the APC is challenging the election, isn't that a valid ground to challenge the election?
Well, constitutionally, the 2022 Electoral Act has introduced new vistas upon which an individual can approach the court. In the 2010 Electoral Act, for instance, we had 4 grounds upon which an individual can present a petition. But then under the 2022 Electoral Act, the last ground of unlawful exclusion was expunged from the law, leaving only 3 grounds. And what are the grounds? Under Section 134 of the Electoral Act, there are 3 grounds upon which an election petition could be presented. 1, that as at the time of the election, the candidate was not qualified to contest the election. 2, that the election was marred by irregularities and substantial non-compliance with the Electoral Act. 3, that the person whose election is questioned did not win the majority of lawful votes cast. They anchored their petitions under Section 134, subsection 1A. And that's to tell you that the candidates of the PDP were not qualified. But then the question is, Section 134, subsection 3 of the Electoral Act has clearly said that an election petition of a person or the election of a candidate shall not be nullified on the ground of non-qualification. Reason being that if it is shown under Section 134, subsection 3, that the person has actually fulfilled all the constitutional requirements. In the case of a governor, Section 177, in the case of a senator, Section 65, in the case of a member House of Assembly, Section 106 of the Constitution of Nigeria, 1999 as amended. All these provisional attributes are actually the same, because under Section 177, that actually lays down the template or the grounds upon which a governor will be qualified to stand for election, there are 4 issues. 1, the age of the person, the educational qualification of the person, he is a citizen by birth, and of course, the 4th one, which is section 177C, is that the candidate was a member of a political party and sponsored by that party. It was not shown anywhere when they presented their petition. And this is the case of the APC on the Plateau. They are questioning issues relating to nomination and sponsorship.
Yeah.
And there are legions of judicial pronouncements and authorities by the apex court that have come up to say, look, issues relating to qualification, disqualification, sponsorship, nomination are all pre-election matters. There are legions of authorities, Suleiman against APC, Indukwe against IU, all of them, Kente and Boacha, have all said that you cannot approach the tribunal that is established under section 285 of the Constitution to look only at events arising from the conduct of the election, whether a candidate was validly elected as the candidate or as the winner of the election, not as validly nominated. Because nomination of a candidate precedes the conduct of the election. And in the case of...
Well, looking at the background you laid, are you saying that the issue of nomination, is not a basis for one to qualify for an election? For instance, and you're talking about pre-election, qualification as a pre-election matter.
Very well.
But what the appellate court said is that pre-election matter, like this one that it adjudicated on, is both a pre-election matter and post-election matter, going by section 177 of the Constitution.
Very
now,
well.
are you saying that this is not enough justification, to nullify this election?
I am in total disagreement with the perverse finding and decision of the Court of Appeal. With due respect to the justices, they misapplied the law.
How?
Under our electoral jurisprudence, the only issue that is pre-election that can actually also appear as a post-election matter is where the candidate falsifies his information in his form TF001, which is now form EC9. And that form is the particular or the particulars of the candidate that he submitted to INEC. That is why the Electoral Act has said, in fact, before now, in the 2010 Electoral Act, we used to have 2 courts, either the Federal High Court or the State High Court. But the 2022 Electoral Act has expunged Federal High Court, leaving only the State High Court. And I look at the issue of disqualification under Section 177C that are coming under. Section 177C says the person must be a member of a political party and he must have been sponsored by that party. Let me take you through this storyline.
Okay, before we look at the story, we were talking about sponsorship.
Yes, it is purely...
And the ground, for the appeal is that the governor,
the party disobeyed a court order.
Yeah, so he was not validly nominated.
Exactly.
He was not validly sponsored by his political party.
Now,
Which is
that is...
Let's look at the background.
Very well.
The contention is around the conduct of primary elections.
Not even primaries, congresses.
Congresses, right.
Yes.
So in that case, there were parallel congresses in the state. Two parallel congresses, that took place. Yes. One under former Governor Jang, the other under Jeremiah Oseni. And both of these congresses, were not authorized, so to speak, by the party because there wasn't any documentary evidence to show that the party at the national level conducted these congresses. 2, there were also claims that the INEC officials were there to monitor this conduct of this Congress, especially that of the Jonah Jang-led faction. But at the lower court, the justice, presiding over the case, asked if actually there are documentary evidence to show that these 2 key parties to the Congress have witnessed it, but none was able to present. So, how can you justify such Congress?
Now, let me correct this impression, which is, of course, the story going out there, especially by the opposition, the APC, trying to feed the public with all sorts of garbage. But then the kernel of this ground one of their petition, that they try to smuggle the question of disobedience to court order, which is non-justiciable, which is not even a ground upon which an election can be nullified, is the fact that...
But that was the basis for the judgment.
Exactly.
Because the court is insisting that you cannot ignore court order.
Very well.
And think it is
now
not...
I am taking you through the processes from the onset up to when we even had a court finding saying that PDP has complied. It was in the year 2020, which was called, it was an unpalatable year for the PDP in Plateau State, when they were actually fracas and crisis within the party. They held a Congress. That Congress was greeted with a lot of criticism, and of course that led the members of the party to approach the Plateau State High Court in suit number PLD J304 2020. Who was the plaintiff in that case? It was one Bitrus Kaze who went to the High Court and said, my lord, we have a problem in the PDP. There was a Congress. Some of us were supposed to participate. Some of us were disenfranchised. And the court said, look, we know that these are internal affairs of a party. The court does not even have jurisdiction to entertain. But then, we are making a finding. PDP, since you have this problem, go back and conduct another Congress.
Yeah, fresh Congresses.
Fresh Congresses. PDP, in the interim, decided, from the documentary that you saw, decided to actually constitute a caretaker committee. What was the essence of the caretaker committee? Because it is provided by the constitution of the party. Where there's a crisis, where there are actually inefficiencies and deficiencies, the party can actually constitute a caretaker committee. That was actually constituted. The caretaker committee superintended the affairs of PDP for some time. And having superintended the affairs, PDP now decided, since this problem is lingering, let us obey this court order. PDP decided, but between...
Did it obey the court order by conducting the press?
I'm taking you there. PDP obeyed that court order. I want to take you because they...
Why did they fail to present evidence that Congress has actually taken place?
Now I am taking you there. When PDP conducted the Congress, before the conduct of the Congress, the Plateau State government wanted to conduct, or was about conducting, state local government elections. As at that time, the Congress had not been concluded, and then they presented candidates to participate in the local government election. But then the same Bitrus Kaze now wrote to PLASE, that's Plateau State Independent Electoral Commission, to say, look, don't recognize the candidates of the PDP because PDP has not complied with court order, PDP has not conducted congresses. The PLASEC, acting on that letter, decided to exclude all the candidates of the PDP. PDP went to court. PDP went to court challenging PLASEC. Why did you have to exclude us? Because it is only a letter you are acting on from a member of the PDP.
Which is in order, because he has the right,
a right to ventilate his bill first. Right. Now he did that, the PLASEC agreed, and of course, that went on. Now, when that case was still pending, that's the case of PDP and PLASEC. Before Justice I. Kunda, PDP went and organized the repeat Congress on the 25th September 2021. Constitutionally, it is only the Independent National Electoral Commission that has the constitutional and statutory responsibility to monitor party congresses, party primaries, and actually the spending and financing of the party. INEC went there and supervised the congresses. Let me even make it...
Which of the INEC? Because the same question was put to, the PDP, at the lower tribunal. I mean, the lawyers, if you like, of the PDP at the law. Yes, you said you conducted this Congress. You complied with the court order by conducting a fresh Congress. But show us evidence. Show us the document, which comes either from the PDP as a party or from the INEC, which you claim monitored the exercise.
Very well.
And none was tendered.
No, with the greatest respect to whoever that is parading or peddling those such kind of information, PDP, I was in the court. I was part of the proceedings.
Are you saying something to the contrary? Are you saying
yes,
there were evidences before the lower tribunal?
Of pieces of evidence tendered, including the video of the said Bitrus Kaze who was actually the plaintiff in Exhibit P1. P1 is the order of the court that said go and conduct Congress. Kaze was the first plaintiff. And then Kaze was number 2 under serial number 1 on that report that was presented. That report was a certified true copy under the Evidence Act. Once you tender certified true copy, it enjoys, no matter how irregular, it enjoys the presumption of regularity. Because INEC issued it. Whoever that issued it, he's a staff of INEC. APC did not say that this person that issued this report is not a staff of INEC.
But did INEC accept it?
INEC even tendered that report, Exhibit 1R1. 1R1 is a report that INEC tendered. INEC brought that report and said, look, we monitor this Congress. PDP comply. And what is even more, there was a candidate, a member of PDP, since it's an internal affair, who participated in Langtan North State constituency election. Having been dissatisfied, he went to Federal High Court in Jos in 2022, and he prayed the Federal High Court that Federal High Court should disqualify all the candidates of the PDP from State Assembly, National Assembly, and the governorship.
Were they not disqualified?
They were not, because the Federal High Court made a finding and said, I agree with the PDP that PDP conducted a repeat Congress on the 25th September 2021, which was monitored by the first respondent, INEC. And that is why the claimant in that suit, named Augustine Tim Cook, was able to participate in the Langtan North. The lawyer that participated in the APC case was the one that handled that matter. The matter went on appeal. And do you know what the Court of Appeal said? The Court of Appeal said, we hereby affirmed the finding and the unassailable reasoning of the Federal High Court. That is a judgment of court. There is a principle of judicial discipline, stare decisis, that where a court has decided, you must follow it. It is the same Court of Appeal sitting in Abuja that in Just Division, it affirmed that PDP conducted Congress. That judgment was tendered at the tribunal. In fact,
where does the Court of Appeal, derives its evidence that the lower tribunal could not ascertain, that fresh congresses were actually conducted in line with the court order? Why the conflicting judgments or reasoning?
I think with due respect to the justices of the Court of Appeal, is either they were obstinate in understanding the facts and marrying the facts with the law, and of course their inability to appreciate the case as presented by PDP. And that is why we had 3 panels in Plateau State. 2 of the panels, the governorship and panel 2 of the State and National Assembly, agreed and gave all the judgments in favor of PDP. It was only 1 panel, presided over by Honorable Justice Tukur, that said PDP did not comply. And those other panels agreed that PDP complied because they saw the reports, they saw the judgments, and all the cases the APC is parading with that said PDP disqualified PDP in Basa Just Not by-election, Panshin South by-election. Let me tell you, in all those cases, I can tell you for free that the court said, why we are saying that PDP does not have a structure is because PDP did not tender a report. This time around, the report that was not tendered in those cases has now appeared in this case. Will you now use that case as precedent? Cases are won and decided based on the merits of those cases, and no one case is similar to all other cases. And that is why the court wrongly agreed with the APC and applied the judgment of Court of Appeal in Basa Just Not in the case of Alkali against Aga. That was a wrong decision.
Yeah, but if you said that, if you are disputing the position of the appellate court that the PDP doesn't have a structure at the time of the election, what happened? Why was PDP excluded from the Congress, that is the zonal Congress that took place? I think, is it in Nasarawa or there, but I can't remember the state now. The PDP in Plateau State was shut out of that Congress because they don't have a valid structure. Why was it so?
Now, the exclusion of PDP from the National Convention or from the Zonal Convention,
Zonal Convention, right,
was not because PDP had no structure. it was because on a legal advice that there was need to make some appropriate sanitization within the party mechanism, and not because PDP...
Why that appropriate sanitization?
It was on a legal advice. And let me even make it clear to you. It was because PDP acted on the legal advice and decided, indeed, we are entitled to appear in this, and the national vice chairman, not central, Theophilus Dekasian, is from Plateau State. He is representing the party at that level. He was there at the zonal convention.
But what happened to the delegates from the state?
The delegates from the state, just like I have told you, it was upon a legal advice. And once there is a legal advice within the party, you are bound to obey the legal advice, because the legal department advises the party rightly in order not to offend the provisions of the law.
Because if the party itself did not recognize, the structure you claim exists, then who else would agree that there is a structure?
There was no point, there was no time in the history of the national, after the repeated Congress of 25th September 2021, that PDP in Plateau State was denied any privilege or opportunity. Quote me anywhere. Until today, I am telling you, Bitrus Kaze, who was the originator of this problem from the Plateau State High Court, is still alive. After the repeat Congress, did he go back to the court to say that I am not in agreement with this Congress? Did he challenge the Congress anywhere? Did he go back to any court? Till today, if the APC or any other political party can furnish me, I am challenging them to furnish me with any court order from any court of competent jurisdiction in Nigeria that nullified the repeat Congress. Once there is no court order nullifying the repeat Congress, it stands. And what the tribunal or the Court of Appeal needs is just, no matter how minute, the semblance of compliance. That is what the court needs, and nothing more.
No total compliance, he said.
In fact, even if there is no total compliance, no matter how minute, since there was a report before the court did not have the right to begin to dissect the report to say, this person was excluded, that person was excluded, because that can only be done in the State High Court or the Federal High Court, and not at the tribunal. Because the tribunal, the job is to look at who won election, who lost election, who was validly voted. This is a mandate.
Validly sponsored and nominated.
Who validly sponsored and nominated.
In this case, they found the PDP candidate not validly sponsored.
That was a perverse decision, and that is why we are challenging it at the Supreme Court, to say that the justices of the Court of Appeal, they are human beings. They are not final. They are not immutable. They are not beyond making errors. And of course, we have seen instances. The governor of Osun State, he lost at the tribunal. He got at the Supreme Court. Uzodimma got at the Supreme Court. Emmanuel Udom lost. Durojiri of Bayelsa lost. But all of them got at the Supreme Court. That's to tell you, the finding of the Court of Appeal is not unassailable. It is not free. It is not final. It is not to say that they are beyond misunderstanding and misapplying the law.
So you think the issues raised, if you like, or the issues relied upon by the appellate court to nullify the election of the PDP candidate are not, are issues that could be reversed at the Supreme Court? Is that what you're saying?
In fact, I have 101% assurance that the Supreme Court that I know, that is full of justices of great wisdom, I am telling you, they are going to upturn that decision. To tell you, number one, that issue is a pre-election matter. Number two, disobedience to court order cannot be a ground to disqualify a candidate in an election anywhere.
Even under Section 177?
Even under Section 177C. In fact, the case of Borno State, Askira Oba, Borno State, disobedience to Supreme Court order. Justice Sirajo and Justice Iheme said, look, this is the wrong forum for you to come. We are not here to enforce court judgments. There is a forum in our jurisprudence. There is a forum for the enforcement of court judgments. You constitute or you institute committal proceedings where somebody is in disobedience of court order. And let me tell you, why the court was even saying, when we attacked them, when they brought judgments to say PDP has no structure, we brought a judgment of the Federal High Court and the Court of Appeal. And the court saw that judgment. And do you know what the court said? The most annoying part of that judgment, which is quite disgusting and unpalatable, is the fact that the justices were saying that the judge of the Federal High Court, Justice Agishi, did not have the right to go into the merits of the matter, having declined jurisdiction. And the law is, in an election-related matter, even in election petition, if you decline jurisdiction, you must go into the merits of the matter, because assuming you are wrong, the appellate court will have the opportunity of looking at the matter. And just to round up this, that finding was taken to the Court of Appeal, and the Court of Appeal affirmed it. So when APC brought disobedience to court order, the cases of Basa Just Not, the case of Plasek, we brought Augustine Timcook, and the Federal High Court said no, that the Federal High Court judge went and started making unsolicited finding in that judgment. And when that finding was appealed to the Court of Appeal, and the Court of Appeal affirmed that decision.
Right. Okay, but then there are similarities looking at the case and the case in Kano, for instance. Both of them are pre-election matters, isn't it?
Yes.
And then the court of the lower tribunal, the lower court in Kano, perhaps also declined jurisdiction concerning the matter of, nomination, membership, party membership. But this resurfaced at the Court of Appeal, which found the lower court to have erred, by not even disqualifying the candidate in the first place, having failed, to meet the requirement of the law. The constitutional provisions of that section, not contesting without membership of a political party, would invalidate, if you like, as held by the appellate court, the entire exercise, that is the election, and the results of the election, isn't it? Is it not the same proceedings, the same trajectory with the case in Plateau?
They are never the same. They are two sides of a coin that can never see each other. The reason is simple. The only similarity in those cases is the fact that there are events preceding the conduct of election. They are pre-election matters. The question of membership, leadership, they are in law what we call non-justiciable. Non-justiciable in law, you cannot even litigate them. For the fact that somebody you're saying...
where did the appellate court, how did the appellate court assume jurisdiction if you said it cannot adjudicate?
Yes, because I am telling you, the justices are human beings. They are lawyers, we are lawyers. There are tendencies for them. That is why if somebody makes a finding, you go upstairs and somebody say your finding was wrong. And that is why the Court of Appeal is now saying the finding of the tribunal was wrong. To tell you they are human beings. The question of this is you must look at it dispassionately, in the sense that PDP, NMPP never said this man is not our member. They never denied him. And they are saying, we submitted this to INEC. We submitted his details to INEC. You remember question of Kashim Shettima case, double nomination. You remember the Peter Obi's case? He said as at the time he left PDP and went to Labour Party, he was not a member of Labour Party. What did the Court of Appeal say? And what even the Federal High Court said? The Federal High Court said, look, what is your problem? NPP can decide to say, even if we have absorbed him, he's our member, and we have given him a ticket.
Yeah, but what the appellate court is saying is that you cannot put something on nothing. It can't stand.
Yes.
You are not a member of a political party, but you contested an election. Right from the onset, you are disqualified from participating.
Who defines the membership of a party? Does it lie in the mouth of your opponent to challenge you that you are not a member?
If they are able to provide evidence, because
when the
evidence provided then was the membership register, and the appellant name was not found in the register.
When it was shown that NMPP had the name of Abba Yusuf as a member of the party, submitted his name to INEC, that he was a member. Now, does the court now assuming the position of political parties, is that the job of the court?
But the court has the right to look at the constitutionality or otherwise of some of those actions or inactions of the political actors. And the concern is that these political actors are living or are neglecting or are not taking serious provisions of the Constitution. They tend to look at political party affairs as outside, not governed by the law.
If you look at that judgment, I just read the copy of the Court of Appeal judgment in Abba Yusuf of Kano State, where the contention of the appellant in that case was the fact that, yes, this person is a member of this party, they submitted his details, the membership register was submitted. For any reason, if INEC refused to submit it or present it, should that person be punished? Should the party be punished for the infraction of INEC?
Is it about submission or about omission? Because if his name is not found, they said they
submitted to INEC.
But if his name is not found in the register,
they said,
does that validate the fact?
For any reason, if INEC could not furnish the court with the appropriate register containing the name of Abba, I did not participate in that case, so I may not know the full gist.
Because I was in the Court of Appeal, during this judgment, and one of the contention around, one of the reasons behind the disqualification again was the fact that he had an opportunity to present his case or to defend or to table evidence that he's actually a member, but he sent someone to depose to an affidavit on his behalf, which also, the court found, to
be defective.
So if that is the case, then what's wrong with the reasoning?
I am telling you, going forward, the overwhelming mandate given to Abba, which of course has not been denied anywhere, if we must foster the democratic tenets of our fledgling democracy, the courts must wear human faces to feel the pains and agonies of Nigerians, to know that the electorates out there who have gone out to exercise their franchise, if you cannot win election in the polling booth, the court should not be Father Christmas. To entrench and force people on the hoi polloi, the masses.
Is it not to ensure justice in respective of who is?
And that is why the case of I think Josiah against the state, though a criminal matter, where Justice Oputa JSC said justice is not a one-way traffic, neither is justice a two-way traffic, justice is a three-way traffic. It is justice for the victim of the offense whose blood is crying in high heavens for vengeance. It is justice for the accused person who is standing trial for the offense, and it is justice for the society whose moral values have been desecrated. Democratic decisions or political decisions must ensure that it is justice being dispensed to Nigerians who have gone out to vote for the candidates of their choice.
Well, okay. Thank you very much for your perspectives. You have another step forward. That is, you can go to the you can go upstairs now, going to the last bus stop, talking about Supreme Court.
Very well.
We wish you all the best.
And just to round up, is just to add that the decisions of the Plateau State High Court was not just perverse in law, it was bereft of substance. The facts were not married there. And we know
your conclusion.
Yes, by my conclusion. And that is, of course, the position of the law.
Right. Okay.
Evidence was tendered to show that PDP complied, and PDP had a solid and has a solid subsisting structure in Plateau State.
Thank you very much, Barrister. I'm trying to get any Barrister
Emmanuel
Mense. Thank you very much for your perspectives.
I appreciate it.
Yes. On behalf of the technical crew, this is where we come to the end of this conversation on daily politics. If you had the engagement, the conversation engaging and informative, you can join us tomorrow, where we'll be back with another interesting guest and, of course, topics. Until then, on behalf of the technical crew, my name is Shafiu Suleiman, thanking you for staying with us.